This hearing starts with a mistake many parents make in family court. The mother believed filing an appeal automatically reopened the entire parenting dispute, but the judge immediately narrowed the battlefield. He locked the case into one specific issue: transportation and exchange logistics.
Schedule regarding the days and the exchange of custody. What you filed was the following. I'm asking the court to appeal the case between Bradley Myers and Taylor Brock. I was sick on Monday, January 27, 2025, unable to make the 9 a.m. time. I'm asking to set aside the judgment until Bradley and I can agree. I am 95% in agreement with the parenting plan. I was unable to drive to exit 40 right now. I'm unable to drive to exit 40 right now because of issues with my vehicle overheating. We've been working in agreement to get her back and forth successfully. I was unaware I had to report the arrangements being elected to the court. So the question that I'm asking, have you and Mr. Myers had any conversations since you filed this notice of appeal about trying to work out some sort of a schedule? So essentially, you're asking to appeal this decision, so you're going to have to prove to me what it is that you're wanting to do differently than what the juvenile court has adopted. You understand that? Right. Mr. Myers, you understand what we're doing here today, that the only thing, if I'm understanding, the only thing you're appealing is something having to do with the exchange and where you're exchanging or the transportation. Is that correct? As far as who's the primary residential parent, the schedule itself, you're not opposed to the schedule.
Yes.
And all you're really asking is to make some modification about this case regarding the exchange of the child.
Yes.
Mr. Myers, are you open to discussing that and any possible modification or changes to that?
Yes, sir, I am. But there's some stuff that needs to be addressed that was addressed in juvenile court that is still happening, and I have some major concerns. And I brought pictures and text messages that one of them, the first most thing that needs to be addressed is my daughter putting on social media that I've not heard anything about this.
Well, you need to understand that right now, the only thing we're dealing with is the appeal that she has filed from the juvenile court, and she's alleging that that what needs to be changed about that, you did not appeal from the from the juvenile court. So as far as what we're hearing today is her appeal. You understand that?
Yes, sir, I understand that.
All right, come up, Mr. Brock. I'm going to have you come up and take a witness stand.
You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God. Thank you.
All right, Brock, you want to tell me exactly? I understand your reasons why. It doesn't really matter why you weren't here. You filed a valid appeal from the juvenile court's ruling, so I need to know what it is. The juvenile court adopted a parenting plan that designated you as the primary residential parent and made him the alternate residential parent. It awarded you 305 days per year and him 60 days per year. It awarded you the responsibility for the care of your child, with the exception of Friday at 5 p.m. to Sunday at 6 p.m. every other week. And then it goes on to talk about holidays and so forth. And then it talks about spring vacation. It also has summer vacation. Transportation arrangements were that the parties will meet for the exchange of the child on exit 40 of I-24 at 501 Hickory Hills Boulevard, Whites Creek, Tennessee. So I need to know what it is that you're objecting to about this juvenile court's order.
Driving to exit 40 at 5 p.m. on Friday and 6 p.m. Sunday interferes with my work schedule.
Where do you work?
I work at Lance's, the store manager at Lance's Pizza.
Okay. And what are your work hours on the weekends?
Typically 3 to 9.
3 o'clock in the afternoon to 9 p.m.?
Yes, sir.
And that's on every Friday? So if you're saying that it makes it difficult, it's not impossible for you to make transportation for the child to meet the father at 5 p.m. on this address on Whites Creek, what are you proposing as an alternative to that?
That he could either come and pick her up and drop her off if he wants to get her and bring her back while I'm working, or that he just work with me on the times and schedule for a time that I'm not working.
But that would mean he wouldn't get any weekend time if you're working every weekend.
He could get from, since, well, she's, for the last 11 years, the time span that he's been able to get her, he's gotten her, I would say, once a month regularly. And with that, if it was once a month, I wouldn't be in the situation that I'm in to have to call out of work so often or get someone to cover my shift. But
well, you realize that he is the father and he has the right to have visitation with your
Yes,
daughter, and it's just a question of whether or not Judge Brigham heard this, and I realize you weren't here,
Yes.
and he adopted what some people call as our standard parenting plan, which gives him every other weekend and holiday visitation and so forth. So do you work Sundays at this Lance Pizza job?
The judge's questioning during this section was surgical. He was not just gathering facts. He was mapping out control points. Every question about where the child stayed, who lived nearby, and whether the father knew the address was building toward a transportation solution the mother could not easily challenge later.
So you work every Friday, Saturday, and Sunday?
Pretty much every weekend, yeah. But there's people in my family that are off on Sundays where Sundays aren't really the issue.
And where is your child on Friday afternoon? If he's not going, if your child's not going with the father, where is your child located on Friday afternoon at 5 o'clock?
She's either with my parents or with me at work.
Where do your parents live?
About a mile down the road from my house.
From your house? And where, just generally, you don't have to give me the exact address, but where generally do you live here?
In Carlisle.
Does Mr. Myers know where you live? He knows your address?
As far as I've lived there as long as I've known him, so he should.
So it's the same address as you were living while you and he were in a relationship? All right. So is that the difficulty of getting the child to and from him, to and from that exit 40 at I-24 on Hickory Hills Boulevard, Whites Creek? Is that the biggest problem that you have right now? Yeah. And everything else you're okay with as far as what Judge Brigham ordered? Mr. Myers, you have the right, asking as your own lawyer, to ask her questions. I'm going to give you a chance to testify as well, but do you have any questions that you want to ask her?
No, sir, I don't have any questions at the time.
All right, step down.
Sorry, I didn't stand up before.
That's all right. Do you have any other witnesses, Ms. Brock? Mr. Myers, do you want to testify?
Yes, sir.
Come on up. I don't know if did we place her under oath when she testified?
Yes, sir. We did. Raise your right hand, please, sir. You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Thank you.
Well, have a seat.
Fairly close to Mark Santo. They picked up. All right.
All right. You were here for the hearing in front of the juvenile judge, and he adopted basically a parenting plan that you've heard me go over, and she's the only one who has appealed from that. You've heard her state what her problems are. Tell me, what do you do for a living?
I'm a general contractor, sir.
And what flexibility, if any, do you have with your work hours?
I do not have flexibility, but me and my wife have worked out where she is off on Fridays to accommodate to go pick up my daughter.
Yeah.
We have worked our schedules out that way.
Does your wife have any problem knowing where she lives and where? What I'm trying to figure out is to give you what the judge ordered.
Yes, sir.
But to arrange a time that doesn't make it as difficult for her And what I'm contemplating, and I want to put it to you, is dividing the time or the transportation can be done one of two ways. Judge Brigham divided it where you meet at a mutual location.
Yes, sir.
The other way of doing it is one party provides transportation to pick the child up when it's going to be your time, so that way you know you're going to be on time to pick your daughter up. And then the other side has to pick the child up from you wherever you're located.
Yes, sir. Well, that's the family plan that the other judge adopted was the family plan that I wrote up. I was the one who put the spot to meet because I live 3 hours away from here.
Where do you live?
I live in Carthage, Tennessee. It's a good distance. So missing 2 days last week coming up here was not for me and my wife both take off work. It's a lot. It's a lot. Just like this morning. The only reason that I come and put this adoption thing, the parenting plan in place is because roughly a year and a half ago, all communication was cut off between my daughter and for about 6 months I didn't hear nothing. So I went and filed this, and then when we finally got to court is when she started coming back to the house. I have text messages there that go back 2 years where she stated that she's had car issues. That's been the excuse for 2 years. I mean, it's been an excuse. And that's another reason that I filed this, because every time that we try to go and get her, it's always something. It's always a fight. It's always an excuse, or can we put it off this weekend, or can we do this or that? Or then having to drive 3 hours up here to pick her up, and then get back to my house at 9, 10 o'clock at night, and then have to drive up here, leave. As soon as we get out of church on Sunday, we got to leave and drive all the way back. It's just too much. I don't get any time with my daughter.
Well, what if I give you the right to pick up your daughter here at where she's located in this address, and then she or her family has to come to your house in Carthage to pick the child up?
That is more than acceptable to me. I just thought especially at the 5 o'clock, they gave her time to get off the bus and meet us over there, and then she could still get back to work and work a couple of hours. I mean, it's her whole family. That was her mom or her boyfriend.
Well,
they all work at the same place.
Obviously, I want to give you the opportunity to exercise your visitation, but I want to not put her in a position where she can't simply comply because of her work schedule. So it seems to me, with her having family that can do it, it puts the burden of transportation equally on both of you. If you pick the child up here, now you two can always agree on something different. Y'all can agree that you are making a different arrangement if that's what you want to do. But if we do it this way, then you have the right to pick the child up at the beginning of your visitation, and then she will have to come and pick the child up, or her family will, at the end of the visitation period at your location.
That's cool with me.
The communication collapsed underneath the custody fight. The father was no longer talking about pickup times. He was talking about being erased from the child's life. School absences, health concerns, reporting issues, hostile messages, all of it painted a picture of a parent operating outside the co-parenting structure entirely.
Now, you had indicated there were some issues that had come up, and understand that's not before me today.
Yes, sir.
But if there are issues, you and she need to talk about that, because obviously if you can communicate, and I'm going to talk to both of you about that, but if you can communicate to address those issues, you're going to have to co-parent your child. How old is she now?
She's 11.
And you still got 7 years where she's a minor, and you're going to have to work together for that.
Yes, sir. And that's one of the things that I thought was in the parenting plan was about the communication. There's been no communication about schooling. I know she's had a bunch of missed school days. But no communication about health issues. And then there's this stuff that's come up about molestation and hurt herself and stuff like that. Like, I've had nobody's told me anything about this until it was found, and then my wife is a mandated reporter. She had to report it. So it has been reported, but that hasn't been addressed. And every time that we try to talk to her, like the text message over there, I mean, she calls my wife all kinds of names, tell her and my wife is here to testify today. I mean, the way that she talks to my wife through the text, I mean, it's horrible, horrible. I ain't had no communication with her in 2 years. But the way that she talks to my wife and my wife has never said a side word to her. And something's got to change where my daughter's not suffering because of it. And I need to know what's going on, because I can't be there to protect her if I don't know that she's being hurt. And that's really all I got on it.
Now, Ms. Brock, you are acting as your own lawyer. Do you have any questions you want to ask him?
Actually,
Come to the podium there.
I actually have a lawyer. I hired Charles Parks to be my lawyer. He said that with the last minute because I had hired him on Tuesday, and then I told him that it got rescheduled to Thursday. So he was like, with the short notice, there's really not much I can do, but I have retained a lawyer. Anyhow, that she has not missed, she has 5 unexcused school days from this whole school year. She has not missed a bunch of school days. And as far
You're
as
testifying, I'm giving you an opportunity to ask him questions. Do you want to ask him any questions? Has to be in the form of a question.
um, required to, I can't, I mean, I don't really have anything to ask, just,
All right, thank you, sir. Sit down. Sir. All right. This case was before the juvenile court, had a hearing in January, and at that time, Ms. Brock failed to appear. She's explained that her absence was due to illness on her part, and she was not able to get here for 9. In any event, she has filed a notice of appeal from the judge's decision, and I've allowed her to present to me the issues that she has. I want to make sure that both of you understand one thing. Under the laws of the state of Tennessee, Mr. Myers is this child's father, and I know you acknowledge that, but that gives him certain rights, including the right to visitation, the right to be informed of any kind of issues with your child. It's not sufficient for him to just be able to exercise and pay child support. He needs to be involved in this child's life. You two have to co-parent this child, whether you like each other, whether you don't like his new wife or whatever. And one of the most difficult things that we deal with are when one of the parties remarries or has a new person in their life. There's a natural resentment. You just listen to me, okay? He says that you and his present wife have had issues and that you talk horribly about her and so forth. That stops today. If it has happened, it stops today, because it's now going to be a court order of this court that you not speak ill about his current wife, that you not use any kind of offensive language when you're talking with her, or when she comes to pick this child up. You're going to be at work, apparently, because my remedy is the only thing they give me to fix things is what we call contempt. And contempt means that if you violate a court order that I put down regarding his visitation, then I will remove the child from your care and custody and put the child in his care and custody, and we'll see how you like going back and forth and having to deal with his wife as far as picking the child from her. So let's forget about whatever the hostility is. Let's set aside any kind of animosity that you have and put this child's best interest first and foremost in your mind. You've got an 11-year-old child. I'm assuming she has, that she cares about having a relationship with her father. And essentially, you've got 7 years to have a relationship with this child, and for Mr. Myers to have a relationship with his daughter.
The court moved far beyond weekends and exchanges and started framing the conflict as a lifelong emotional pattern. Weddings, graduations, grandchildren, none of that was sentimental filler. The judge was forcing both parents to visualize the cumulative damage of unresolved hostility.
If you two can set aside these problems, cooperate to let him have this visitation, work together to modify things if a situation arises that you need to do something different, you can agree on it. But if you can't agree, you're stuck with what I'm ordering today. And if the two of you can set that aside, then your daughter can grow up knowing that mom and dad can get along and that they can, that things can be okay. If you don't do that, you're going to ruin every major event in your child's life. Every birthday, every school function, every graduation. Think about that. When your daughter sees the animosity between the two of you, then what does that effect that has on her? She loves her dad, she loves her mom, but she sees the two of you with so much hatred towards one another. All it does is upset her. It makes her anxious, makes her upset, and causes her to dread every major event in her life. She will dread every school function that the both of you are going to be there because she's going to be worried about whether mom and dad are going to be fighting and fussing and cussing at each other, or whether mom's going to get into it with dad's new wife or whatever. You look forward to these school graduations. You look forward to holidays. You look forward to things like high school graduation eventually. Your daughter may want to go to college. Both of you may want to do that. You both want to be involved in that first day of taking her off to college. Don't make it something that she dreads. Don't make it something that she's upset and anxious about. Work together to make it as comfortable as possible for her and put aside this animosity, and she can grow up as well adjusted as somebody who grew up with both parents in the same home. But I'm telling you, eventually she's going to get married. I assume most kids do. Eventually she's going to have children. You're going to want to be involved in that. And you're not going to want to ruin your daughter's wedding day by having an argument about whether or not mom and dad, having her worry about whether mom and dad are going to be arguing, fussing, and fighting, or whether mom and dad's new wife have gotten into it, before the wedding and so forth. And I'm talking to both of you about this. I'm not talking to one of you more than the other. But eventually you may have grandchildren, and it's a great joy to have grandchildren, to be able to share that, and to be able to be at things for your grandchildren's events for them. That's a part of their life. It's a part of your life. You still got, both of you are young by my standards anyway, and I think you need to both think about the fact that you got a lot of life left to have with your daughter. It doesn't end when she's 18. It continues on until the two of you pass from this earth. And if you want to have a good relationship with your daughter, if you want to both be involved in your children and your grandchildren and make their lives as comfortable as possible, it can be done. But you got to work at it. And that means when something happens that normally you might get ticked off about, take a deep breath, count to 10 or whatever, and let it go if you can. Now, I'm not telling you to forego your rights, but I'm telling you to try to think about, instead of always about my right, think about what's best for your child. In any event, I think you both have an opportunity to start fresh and go from here. I am going to modify the court's order that put down to leave the visitation schedule exactly as it is, but I'm going to order that he begins his visitation on Friday, every other Friday, by having either he or his wife will pick the child up at your home here in Stewart County, or some other location. If you want to designate a location in Stewart County, you two can agree to meet somewhere in Stewart County, but he'll have to come here to get the child. Then your family will have to go to where he lives in Carthage, or at some place the two of you can designate rather than his house. But I'm going to put it that way because that shares equally the transportation burden, and it gives you the opportunity for work not to interfere with your work, but it gives him the same amount of time. His wife has every right to provide transportation for this child if that's necessary, and there will be no animosity expressed in any form or way, shape, during the exchange of the child or anything else. Both of you are going to be prohibited from making any derogatory remarks about the other to this child or allowing anyone else to do that. Okay? Let's put this child's best interest first. I think you both want to be good parents, and I think you have the opportunity to. So let's work on that part, and we will see how this works out. If it doesn't work, then we'll address it. And like I say, the problem I have is the remedy I'm given is a sledgehammer, contempt. People go to jail. Custody gets removed. Custody gets modified. I don't want to do that, but that's the way I have to deal with it. So that's the order of the court, and I will have to have an order prepared and typed up that modifies this parenting plan. But otherwise, you understand the same schedule applies. I'm just changing the transportation aspect of it. That'll start on the next visitation. All right, thank you.
The final ruling carried a hidden lesson most viewers miss. The mother appealed, trying to reduce her logistical burden, but the court redistributed that burden in a way that ultimately gave the father more structural control. Now he controls pickup initiation, while her side absorbs the long-distance return responsibility. That is the danger of weak appeals in family court. If the judge believes the original order was already fair, reopening the issue can backfire badly. The court also formalized behavioral restrictions during exchanges, which means future hostility now risks contempt consequences immediately. Then the commentary afterward exposes the broader reality surrounding many custody disputes. Resentment toward new partners often becomes the silent engine driving conflict. Whether that interpretation is fully accurate or not, the judge clearly believed emotional hostility had become the central threat to successful co-parenting. By the end, transportation was no longer the real issue. Trust, control, and emotional maturity were,